Okay, welcome back. We are now moving on to the handout that I have labeled as handout 3. I believe on Blackboard it is called Intro to Property Law, and we'll spend a little bit of time discussing that. We're basically into week 2 of the course at this point in time. Okay. Now, the initial part of this handout goes over some of the things that we've previously covered in the first week. It talks about the sources of property law. It talks about how the Constitution ties into that. Talk about stare decisis, the idea of precedent, that the courts will follow their own decisions. Statute being a law created by legislation. Legislation being the act of the legislative branch of government, which is the Congress. On the federal level, case law, again being another word for stare decisis. The common law, that body of principles and rules that came out of the English case law, prior court decisions. Now, having gone through all that kind of quickly again, because we've already spent some time on it, we get into property law for the first time as a subject of its own. One of the first things you need to find out, we need to discuss and discover is exactly what is property. And you can get all kinds of answers to that. People will say it's something you have, it's something you own, it's something you can get, something you can buy or sell, all of which are true, but none of which individually really lets us know or tells us what property is. One of the examples I use in class is to ask people, is the moon property? And there'll be various answers. Well, yes, some people say it is because Americans have been there, or we landed a spaceship there and put a flag there. Other people say, no, it's not property. Nobody owns it. It can't. Nobody has control of it. Nobody can do anything with it at this point in time. And the argument usually will roll around the classroom for a few minutes. My definition of property in a legal sense is that property is anything that can be subject to ownership. And we'll get into the definition of ownership in a minute. It can be anything of value, all right? It can be the rights that a citizen has in relationship to a physical thing, such as the right to possess, to use, to dispose. It can be anything that has value or worth and over which an individual can have legal rights. And I usually say two things go into property. One, it has to be in existence. It has to be some reality that we're talking about. Although when we get into intangible personal property, we'll see that thing can be ideas, not necessarily physical, but it also has to have value. And what gives something value? In my limited philosophical view of the world, there are basically two things that cause something to have value. Number one, it has utility. It's useful. A hammer is valuable because you can bang a nail with it. A stapler is valuable because you can hook together two pieces of paper with it. A piece of paper is valuable because you can write on it. You can use it for things. So things have value because of their utility, of their usefulness, but then there are other things that have value just because we like them. Diamonds are valuable. Now, yes, there are industrial uses for certain types of diamonds, but the most valuable diamonds are not valuable because of the industrial uses. They're valuable merely because they are pretty, and we like them, and we want them, and they're involved in our mating and marriage rituals. They are just something that is socially, ethically, not ethically, but emotionally desirable. And because of that, they have value. Why does a Van Gogh painting sell for $34 million? It's nothing but canvas and dabs of paint put on the canvas, put into a pretty frame. However, because of who made it, because of its symbolism, because of its appeal emotionally, it carries tremendous value because of its rarity. Sometimes things are valuable just because there are not many of them, and I want to have something that no one else can have. But again, it's the emotion. That's an emotion. That's an idea that you want to possess something that nobody else has. So property basically is anything that can have value to human beings, whether useful or emotionally, and over which we somehow can have rights. We can have what's called ownership. Now, ownership, in my definition, is the right of one or more persons to possess and use a thing to the exclusion of others. So again, this idea of this is mine, you can't take it, you can't have it. So ownership has this connotation of I have it, you cannot. Unless I give you permission, then you can have it. If I withdraw my permission, you might have to give it back. But this includes rights of possession, enjoyment, disposal, all right? All as being something essential to our right to control, handle, and dispose of a thing. So it's basically ownership is this idea that we have power over this thing, we have control, and no one else has it except the people that we share it with or decide to share it with. Now, ownership is a broader concept. What does it actually mean to own? And here I say it means to have legal title. It means that the law recognizes you as the owner, that the law recognizes your ownership. Because in reality, short of having guns and knives and swords and broadaxes, the only way you can enforce your ownership or determine your ownership if there's a question about it is through the courts, through the law. So to own something at this point in time in our society basically means that the law would recognize you as having ownership, as having possession and control. We will talk about this at various lengths as we go through personal property and real estate, but just some simple concepts. In order to control motor vehicles, because they're highly valuable and highly movable, they can be 5 states away in 3 hours, the governments have come up with a system called title certificates. And so basically the state keeps track of who owns each particular vehicle. Every vehicle has a VIN number, a vehicle identification number that is totally unique in all the world. It is embossed on the parts of the vehicle in various places, so you can always find it if you go looking for it. And a title certificate will be issued for that vehicle using that VIN number, saying that Mary Smith is the owner of this car. And in reality, at this point, it is very difficult to defeat a title certificate. Once the state has issued it, whoever they say is the owner, for all practical legal intents and purposes, unless you can show unmitigated fraud or theft, that whoever's listed on that certificate, the state says they are the owner. The law recognizes the state's power to do this, and so therefore they have ownership of that vehicle. That's just one manner in which you get ownership. We'll talk about this at length as we get into the next week's part of the course. But I just want you to have that idea at this point in time. So property is something that has utility, or emotional connectedness that we value, that we place value on it. And then ownership means we have the right to use and control. And ownership is a function of the legal system. Ownership is determined by who the law says holds the right to possess and control. Okay, enough theoretical stuff for a moment. Now, I said back in one of the other lectures that one of the things that lawyers love to do is we love to classify. The whole history of the law has been breaking things down into further and further and further and further, smaller and smaller, more precise classes of things. And that happens in property. So we have property law, which is a section of the civil law. The civil law includes wills and trusts. It includes domestic relations. It includes contracts. It includes civil procedure, and property is one of the major categories of the civil law. The civil law being a broad category of law, law being broken down into criminal and civil law. But property is broken down even further. There are two basic property laws, two basic property concepts. The first one is real property. Real property can also be called real estate, and it is basically the land, whatever is attached to the land, and all rights issuing out of, annexed to, or exercisable by someone concerning that land or about that land. So, to put it simply, real property law has to do with land, rights in the land, things attached to the land, period. Personal property is the other category. Personal property has the easiest definition you're going to learn in your entire legal pursuit of education and knowledge. Personal property is any property not real estate, everything else. All right? So personal property is anything that is not real estate. Cars, boats, trains, planes, clothing, jewelry, patent rights, copyrights, computer programs, music programs, intellectual property, contracts are all come under personal property. Bank accounts, annuities, shares of stock are all personal property. Personal property is further divided into two large categories. There is tangible personal property and intangible personal property. Tangible personal property means it has physical reality. You can touch it. You can hold it. It literally comes from the Latin word tangere, which means to grab or to hold. So tangible personal property has physical reality. Again, furniture, clothing, cars, boats, planes, tools, musical instruments. You can go on and on and on and think about all the physical things that you can own, and they fall under tangible personal property. Your cell phone would be tangible personal property. Your computer hardware would be tangible personal property. Then the second category of personal property is intangible personal property. And by definition, again, if tangible means to touch, intangible means you can't really touch it. It doesn't have physical reality. Certain things, stock certificates, savings books, contract rights, copyrights, have no physical reality. Now, you might say, well, I have a paper share of stock. Well, yes, you do, but the paper is just a notation for the reality, which is the equity that you own in a corporation. A credit card is intangible personal property. Yes, there is this little plastic card that's worth 1/100th of a penny. They print them out by the millions every day. The card is not the reality. The reality is the contract rights between you and the bank that allow you to use that card to basically borrow money when you buy things and then pay the bank off at a later date. That is an intangible reality. And the card, again, is just a symbol representing the contract right, which is the reality behind all of this. When we get to money, money is a little bit more complicated. Certainly coins, particularly the gold or silver coins, I would say there's tangible personal property. There's inherent value in the metal that makes up that coin. What happens when we get to paper bills? Very different story. What's the difference between a $1 bill and a $100 bill? It's basically an amount of zeros printed on that piece of paper. If your bill gets half burned or a third burned, you can still turn it into the bank and they'll issue you another one. So paper money does it does have a certain physical reality because we're so used to handling it and passing it around in commerce and that, but it also has an intangible element because It can have different denominations printed on what is basically the same paper. So there are some things that overlap, that kind of mix and that are hard to quantify. Computer programs, software is certainly intangible personal property. I would suppose that Bitcoin and the other digital currencies would be intangible at this point in time. Your bank accounts are intangible. You hand physical money, paper money, over to the bank to put into the account. They don't keep that physical money. They basically give you a contract right in their books to get an equivalent amount of money out from them at some point in time to take it back from them. Now, there are certain things in the world that begin their life as tangible personal property, but then become attached to real estate. And if you remember a definition I gave you a few minutes ago, real estate is land and anything attached to it. A fixture is a piece of personal property that has become permanently attached to real estate and thereby is now part of the real estate. Certainly, if I am building a house, I dig a hole in the ground, I put a concrete foundation 7 or 8 feet into the ground, and then I take bricks or boards or whatever else you'd use today to concrete blocks to build a building attached to the foundation. All of those things, the cement that makes up the foundation, the rebar that goes into it, the boards, the bricks, the cinder blocks, they were all pieces of tangible personal property, but as we put the foundation into the ground, we're attaching it to the land. It's a fixture. It becomes part of the real estate. As we attach the boards to the foundation, as we put the bricks on the boards, as we put in the wiring, the plumbing, the plasterboard, the fixtures, the lights and other things that are hardwired in, all are considered fixtures at this point, and they're part of the real property. And somebody might say, well, why is that a big deal? Well, it is because we need to know where certain things stand. As people are dealing with each other, we need to know who the law says owns whatever. If I were to sell a house in a purchase and sales agreement, if I don't expressly state something contrary, when I say I'm selling you the real estate, by legal definition, that means I am selling you the land, the foundation, the structure of the house, all the plumbing, all the light fixtures that are hardwired in, the heating system, the plumbing systems, the burglar alarm system, the security systems, anything that's hardwired in. If you have an in-home theater and the components are hardwired in, unless you specify otherwise, when you say I'm selling you the real estate, all of that goes with the house by definition. So you cannot, the example I would use from years ago is that, you have grandmother's beautiful crystal chandelier worth $10,000 hanging in your dining room because you inherited it. And it makes the house look really nice, makes the dining room look really nice. And when you're selling the house, you leave it there and you forget to put a clause in the real estate contract saying excluding the chandelier and dining room. Come the day of the closing, the people go for their last walkthrough through the property to see what the house is like, to make sure it's still the condition, and the buyers realize that the chandelier is gone and they start complaining, where's that beautiful chandelier? We thought that was coming with the house. You go, oh, no, I didn't mean for that to come. If you didn't specifically separate it at the point when they signed the contract with you, it was part of the real estate, it belongs to them. Another example, a tenant installs a ceiling fan, buys very expensive drapery rods that are hard, that are screwed into the woodwork on the wall. By attaching those things to the landlord's property, unless they have an agreement, which hopefully will be in writing, with the landlord saying these items still belong to me, the minute they attach them to the underlying property that's owned by the landlord, they're a fixture, they become part of that property. When the tenant leaves, they must leave those items. So it's very important to know what the law says about this so that you can protect yourself, so that you can know your rights, so that we can have some kind of understanding about that. A contract is an agreement between two or more individuals which is legally binding, which means it's enforceable in court. And contracts most usually are for the exchange of goods and services, exchange of money for goods and services, or goods and services for each other. But they are private agreements between individuals, and every contract creates a property right. It creates a right of ownership. If I'm buying the car, I have certain rights in the car now. If you're selling me the car, you have the right to collect certain amounts of money from me, payment from me. So the contracts are very often the mechanism by which we exchange contract rights. And we'll talk about that at length when we deal with the different ways of handling personal property, and certainly when we get into real estate. But the contracts in themselves are a property right. It has a certain value and a certain reality. Hey, now, many of you have probably had contracts, many of you have not, because we're going to be talking about them in terms of personal property, and then again, when we get to buying and selling real estate, we're going to go over real estate contracts. In particular, I want to just get some of the basic terms and ideas about contracts down so that everybody in the class is kind of starting off at the same place. So those of you who have had contracts already, forgive me, there's going to be a quick summary. My experience has been that you forget 3/4 of it a semester after you've had it anyway, so it'll probably be helpful in the long run for your career to kind of listen to this again. Elements of a contract. What has to be present to make a contract a valid, enforceable agreement? Well, there are 5 things. There has to be an agreement. 2 or more people have to agree that something is going to happen. There has to be consideration. Now, consideration, when I was in law school, my contracts professor spent 9 weeks trying to explain consideration, and I came out more confused than I was when I began, partly because they were not a good teacher, I've discovered in years past, but partly because the law tries to make this more complicated than it is. Consideration is a concept that there has to be an exchange of value. So if I am buying a bushel of potatoes from you, there has to be an exchange of value. I am giving you money and you are giving me potatoes. We both have to give up something and we both have to get something. There are other ways to change ownership of property. There are gifts. There is property that is lost and found. There are other ways by which ownership may change, but they are not contracts. For it to be a contract, there has to be an exchange of value. Both sides are giving up something. Both sides have to get something. Does that have to be equal? Basic answer is no. If the parties are freely agreeing, you have a baseball card printed on a piece of cardboard. What is that worth? If it's a rare card from a player from the 1920s, I might be willing to give you $100,000 for that little piece of cardboard with the picture of a ball player printed on the front of it. Who determines the equality? The parties determine whether it's a good deal or a bad deal. And if we were studying contracts, we'd spend a lot of time talking about how the courts do not even want to get into this. They want the parties to set the price. They want the parties to determine what's being exchanged, because that is a very individual reality. How much am I willing to pay for something? How much do I need to get to give something up? And the same thing, when we get into real estate, we're going to find out that real estate agreements, if there is no price listed, if there is no way to determine exactly what the price was supposed to be, then the contract falls, it fails. Because the courts will not second guess what the parties were trying to do in most situations. There has to be mutual assent. Mutual assent means that there basically is no fraud, that everybody's being honest, that everybody knows the true facts, and that we're dealing with reality. We're not trying to get something over by fakery or by misrepresentation or lying. And trying to sell something for what it is not. There has to be legality, right? As of the moment, cocaine is still illegal. We can enter into an agreement where you're supposed to deliver X ounces of cocaine to me for X amount of dollars. It's not a contract. It's not enforceable. The ownership of cocaine, the buying and selling of it are per se illegal at this point under the statutory framework we have. So you can have the most beautiful, written, wonderful agreement with all the other elements. If it's illegal, it's not a contract. And there must be capacity. Today, the two basic capacities are you must be over 18, a minor cannot enter into contracts, their contracts have to be ratified by a parent or a guardian, and you must be of sound mind. Now, this gets a little bit interesting because we presume that everybody is of sound mind, which is a dubious presumption at best, but that's how we operate. So sound mind capacity basically means you have not been placed under guardianship where your right to enter into a contract has been taken away by the court after having determined that you don't have the mental ability to handle your affairs properly. Okay, contract rights can be assigned. So if I enter into a contract with somebody, I don't have to be the ultimate person that fulfills the contract or who gets the benefit of that contract. I can assign my rights to someone else. Now, this seems like a strange concept at first, but it actually makes the world go round, and a lot of business dealings are involved with assignments of rights. Several things about assignments. Number one, if we don't want rights to be assigned, we need to put that in the contract at the beginning. If there's no language prohibiting assignment of rights, then the rights can be freely assigned. And the other party, the party who's watching that happen has no way to stop it. An example of this would be right now the housing market is as hot as it has been over the last 10 years. Prices keep going up. I don't think that's going to be for long, but they have been going up over the past year. COVID or no COVID, the value of real estate in many places has been rising. You can get in that type of situation, you're in a situation where I decide to buy a piece of property. Gee, they're selling this property for $250,000. That's a really good deal. I'm going to buy it. I sign a contract with the owner to, in 30 days, I'm going to have the money. I'm going to give you $250,000. You're going to give me ownership of this piece of property. We have all the elements of our contract. We sign the documents because land deals have to be in writing. And voila, we have a contract. We have an agreement. All of a sudden, Mary comes along and says, "Oh, I heard you're buying that house down the street." She goes, "I'd give you $300,000 for it. I love that house. I've always wanted to own that house. I'm sorry I didn't see that it had gone up for sale." Now, I can do a couple of things. I can go through all the expense of getting my mortgage set up, having my title examination, and having my closing, buying the house for $250,000 after I paid $4,000 or $5,000 in expenses, and then selling it to Mary for $300,000. So I'll end up netting about $45,000 there. Or I can assign my contract to her and say, "Good, Mary, you give me $50,000. I'll assign my contract, and then you just have to show up at this closing in 30 days with $250,000, and the house is yours." That happens more often than you think, particularly where markets are going up. That's a rather common phenomenon to have happen, even in real estate, even with items as big as that. It certainly happens all the time in what we call commodities, which are the buying and selling of raw materials like cattle and agricultural products, timber, minerals, that type of stuff. A very, very important reality, this ability to be able to buy and sell the contract rights. At one point in time, my next door neighbor got bored just playing the stock market and decided he was going to start buying and selling commodities futures. And a future is basically a contract to take delivery of something like wheat or corn or hogs, pork bellies, at some point in the future when they've fully grown and developed. And so I was over his house one day and he was on the computer. I said, "What are you doing?" He said, "Oh, I just bought 3,000 pork bellies." Well, that's 3,000 slaughtered pigs, carcasses. And I said, "You did?" He said, yeah, delivery in 3 months. I said, "Dear God, please assign that contract. I don't want a truck with 3,000 pig carcasses showing up next door to me a couple of months from now." He never had any intention of taking possession of those items. He wanted to get into the contract because he thought that they were selling for a very low price. And of course, his hope is that he can assign that contract, sell it to a third party, and that when the 30 days or 90 days are up, he does not have to take possession of 3,000 pork bellies. That truck will happily be sent on to the person who bought the contract from him. All that my friend will get is a check for the money that he got for selling the contract, which he will turn around and use to buy more commodities with to trade with. So these are very common realities. They happen all the time. And when you get into wheeling and dealing in some of the bigger items in our economy, this is how things are done. Now, one warning here. Now, again, you can always prevent your contract from being assigned by putting language in it saying it's not assignable. And number two, there are a certain category of contracts where the law just says these are not assignable. And these are contracts where somebody is agreeing to undertake a duty. The example I use here, I have this 120-year-old Victorian house. It needs to be painted all the time. And I know, come next year, the house really needs to be repainted again. So I start looking around now in the winter for somebody to come and paint the house as soon as it gets warm. And I ask around. I go on Angie's List. I go on the different websites that are available. I talk to my friends. I talk to my business associates. Do you know any good house painters? I need to have the outside of my house painted. And what comes out is I hear from a number of people, ABC painters are the best. They give good prices. They do quality work. They're excellent. You're really going to like them. They point out some houses in the neighborhood that have been done by them. I go look at them and say, God, they did really good work. But as I'm doing my inquiries, I also found out, whatever you do not contract with XYZ. They are horrible. They hire people who don't know what they're doing. They create chaos and havoc. Go look at this house. They made a mess of it. It had to be it's going to have to be repainted again because they did such a horrible job. So I get on the phone to ABC, call them up, say, send over some paperwork, come do an estimate. I'll get my house painted. They give me an estimate. We sign a contract. I give them $500 up front for a $3,000 or $4,000 deal. And come May 15th, they're supposed to show up and start painting my house. Again, this happens all the time. I'm entering into a contract for future services. They now have a duty to perform in the future. And May 15th comes around. I hear some commotion on my driveway. I look out the second floor window, and there's an XYZ truck pulling up into my driveway. At which point I quickly run outside and say, whoa, don't you dare take a can of paint off the truck. What are you doing? Why are you here? Who are you? Who told you to come onto my property? And they pull out my contract and say, oh, ABC assigned it to us. We're coming to paint your house. The law says that you cannot have an assignment in those situations without the permission of the other party. And the reason for that is what's happening here is I'm not just attempting to buy something that's static, something that every one is like every other one. When I'm contracting for personal services, part of the deal, part of the consideration, part of what I want to get is the expertise and professionalism and ability of the particular person with whom I'm contracting. And because that is such a heart of the deal, such a significant part of the deal, the courts have long said that now in what they call delegation of duties, personal service contracts, you cannot delegate your duties to a third party without permission of the original contract holder. So here in this situation, I have every right to say to XYZ, say, leave my property, you're trespassing, go, and calling up ABC and saying, if you don't get here tomorrow to stop painting my house, you have breached our agreement. This would apply, if you start thinking about it, this applies to a multitude of situations in our society where we have basically moved from a manufacturing economy a great deal to being a service economy. So this would apply with your doctor, your lawyer, your accountant, your dentist, your the person who does your hair, you can just think of if you contract to have photographs done at your wedding, have a painting done of your children, of your dog, whatever. Yeah, and think of all the different situations in society where somebody is rendering a service to you, and you go out and you hire them and you agree to pay a particular price because you've heard about the quality of their work, or you've investigated and you know the quality of your work, and you're not contracting just to get it done, but to get it done by a person with a high degree of skill so that you'll have a high degree of quality in the product. And therefore the court says, while contracts for goods can generally be assigned, and even real estate can generally be assigned without any problems. You can't stop that if you're the third party. When it comes to contracts to perform a specific service, to do a particular duty, those cannot be assigned. They can only be changed with the express, with the absolute permission of the third party, of the person who's supposed to be receiving the goods and services. Which is supposed to be the second party. The interloper would be the third party here. But I think you get the idea. So there is a distinction between contracts for goods and contracts for services, particularly when those services are of a nature where a high degree of skill or education or expertise are involved. Now, there is one reality about assignment of contracts that kind of throws a monkey wrench into this that everybody has to be careful of, and that is that when you assign a contract, the person who is doing the assignment, the person who's giving up their rights under the contract is called the assignor. The person who gets those rights is called the assignee. So let's say that I have entered into a contract to have 15 pieces of lumber delivered to my yard on such and such a day. The particular lumber company I'm dealing with got super busy. They assign my agreement to another lumber company. Because I'm buying goods, I really don't have any say in that. So lumber company 2 shows up, dumps some wood on my driveway, and I wanted first quality, finished quality pine boards, and what I've got here is rough pine boards. It's not what I contracted for. The contract has been breached. The law says I can go to company number 1, who I had the contract with. They're still responsible. Even though they assigned their rights under the contract, they are still responsible for seeing that I get what I was supposed to get. So I don't even have to deal with company number 2. I can go right to the company I contracted with and say, hey, you hired somebody else to send over the goods. They weren't what I ordered. You're in trouble. I'm suing you. Now, they could turn around and sue the middle person, because part of their deal should have been that we'll sell you this contract, you give us money, but you have to perform on it. You have to make sure you provide Mr. Walsh with the goods. But just realize that you are not, as the first party, the assignor, is not released from the deal. They still can be held liable in court if the assignee does not perform the way that the contract was supposed to be performed. Now, the only way out of that is if we enter into something called a novation. And a novation, think of the word novo as new. It really means we're entering into a new contract. So I have a contract with a company to buy the wood. They tell me, oh, Mr. Walsh, we overbooked, we're over, so we can't do it. However, there is a company down the road. They will agree to sell you the lumber for the same price. We would have sold it to you, same delivery date, same quality. If I agree at that point, if I'm brought into that and say, all right, I agree, I will accept this other contract, and I'll let you guys go. At that point, what's happened is I've basically made a new contract with the second lumber company down here. And as part of doing that, I can agree to let lumber company number 1 go. However, if I don't agree to it, it's not an novation, it's still an assignment, and they would lumber company number one would be on the hook. But you can see where in particularly commercial situations, buying and selling and dealing with people, there would be situations to say, oh, all right, you can't provide me with the product, but somebody down here can. Okay, I'll let you go and I'll get it from them and we'll do business next time. And particularly if you have a business relationship, you want to keep up with somebody, you'd be inclined to let that happen. If you're dealing with a party that you're only dealing on one-shot basis or once every few years basis, you may not want to. You may want everybody on the hook. Some realities about assignments and about contracts. Contracts are always subject to claims and defenses. And claims and defenses are legal reasons why a party may be excused from performance of their duties. All right? And this is particularly difficult for somebody who is an assignee. If you are receiving contract rights, you really need to check into the scenario to make sure that the assignor hasn't done something for which they could be sued. Because if they've done something that would allow the other party to sue them, you as the assignee are going to be subject to that lawsuit. You don't get better rights than the assignor has. Some of the situations that create claims and defenses are failure of consideration, fraud, failure to perform, set off, which means there are underlying debts owed between the parties, illegality, unconscionability, duress, undue influence, minority, lack of mental ability. These are all things that you would discuss at length in your contracts course. You'd spend the whole semester going over them basically, but just be aware of the fact that if you do get into a contract by way of being an assignee, be very careful to check out, and I mean, you can do it if there's nothing in the contract, you can do that without telling the other party, but it really behooves you to talk to the other party to make sure that they don't have any claims against the assignor that may undo the contract or make the contract less valuable because there's a certain amount of set-off of monies that they'd be able to claim. And then let's just finish up this section quickly, some rules of assignments. An assignee takes his or her rights subject to all claims and defenses to which the assignor was subject. That's what we just talked about. An assignment cannot increase the duties of the other party without that party's agreement. All right? So if it said that the car, I was able to pick up I'm buying a car from you and I was able to pick it up at this location, and you assign my contract to another auto dealer who's 40 miles away, and you now say, oh no, I turned that over to them, you gotta go pick up the car from them, Mr. Walsh. I don't have to drive the 40 miles. The car still has to come to your location where the contract says I was supposed to pick it up. An assignment without innovation does not release the assignor, does not release the original parties. Delegation of duties for services that require personal skill are not recognized by the courts, and the other party to a contract has no right to stop or prevent an assignment unless the contract itself stated there would be no assignments. Okay, that finishes up this section, basically finishes up what we're doing for week 2. I will see you later in another video at another time and place.